Urban. Judge, welcome back. I'd like to associate myself with parts of what Chris said there in his closing. I would differ with him about whether or not getting to precision on judicial philosophy matters, but you know that. You and I have been wrestling about it for a couple of weeks. But I'd like to affirm Chris's point about the beauty of the hymn to America you told, and through the eyes of your parents and the changes, the growth in the country over the course of the last two generations. And the Wall Street Journal had an editorial this morning that said pretty much the same thing as Chris just said, which is that the hymn to America that you gave in your opening on Monday afternoon and some of your comments yesterday were inspiring and beautiful. So I associate myself with Senator Coons on that. I'd like to talk a little bit about your time as a judge and particularly how you see development and growth and change over that time. So take us back 9 years and then maybe 5 years ago and then today. How has your approach to being a judge changed from year one to year five to today?
Thank you, Senator. I do think there was a little bit of growth. I hope there was a little bit of growth. Certainly in year one and year five, I was still a district judge, and both of those years differed dramatically from my work as an appellate judge, which is where I'm currently stationed. In every job, in year one, you're new, you're trying to figure things out. I don't know that I had quite pinned down at the very beginning exactly how I would approach cases, but by the time I got to year five, I think I had a really good sense of this judging thing and was able to demonstrate in my opinions, the many, many opinions that I've written, the way in which I go about making my decisions. I was able to demonstrate clearly, I think, that the particular parties in the case, the issues in the case, what it's about from a standpoint of personal preference is not an issue. I'm setting those things aside. I am ruling from a position of neutrality and trying to determine in every case what the law requires. I am looking at only the facts and the law in the case. I'm evaluating the arguments of the parties, and if it's statutory interpretation, I'm trying to ascertain what Congress has intended. I am committed, I think my record shows, to the understanding that that is the role and the only appropriate role for a judge.
I'd like to talk a little bit about the troubling pattern we see on law school campuses and across higher education more broadly, especially in the last 5 years. There's obviously a trend toward shouting down and canceling opinions that are outside the left-leaning mainstream, calls for firing professors, canceling professors, shouting down and sometimes threatening speakers who bring diverse opinions, calls to discipline fellow students. These tactics are increasingly commonplace, particularly against conservative speakers and professors and students, but also increasingly against traditional liberals. I'm a former college president, and one of the sort of oddities that doesn't fit inside the tribalism of how a lot of times media covers things in D.C. One of the oddities for me is how often I have liberal professors reaching out to me saying that their experience on campus is becoming much less interesting, that the divide on American political campuses is less and less conservative policy leaning versus liberal or progressive policy leaning, but more and more liberal versus illiberal. And I think these campaigns are obviously deeply problematic. They shut down debate rather than teaching students how to engage ideas that they might not have encountered before, which is also a pretty decent definition of education. If you already knew everything before you ever encountered a new idea, you wouldn't need to write checks or take time off of productive life. So there's obviously a tendency in response for students to self-censor rather than learn from each other, and this robs students of the chance to engage with ideas from across the political spectrum. But in particular, in law schools. It robs students of the opportunity to learn how to consider an alternate position and argue a different point of view than they might have had. So given that you're a debate champion in earlier days as well, I'd like to ask if you agree that law students should be engaging with ideas from across the political spectrum, even those they disagree with, rather than trying to shun those different ideas.
Thank you, Senator. Let me just say, in part because these issues are things that could implicate matters that come before the courts, I will just say that as a general matter, law school, like many schools, is a place where ideas and perspectives are considered. And in the law, as I've said, it's important for the judge who's making the decision to have different arguments. And so one of the things that traditionally happens in law schools is that you are trained in law to make arguments that are at times not even the arguments that you personally agree with, because the understanding is that in litigation, in disputes that come before the court is going to want to hear from different viewpoints. So in that sense, the essence of legal instruction is to have different arguments being made, because that models in great part what happens in a courtroom.
I really am not trying to ask any kind of gotcha question here. I suspect we highly agree, so I don't understand the qualification you put at the beginning. There's no sort of second-order fork on my question. It is better to debate ideas that you disagree with than shout them down, isn't it?
It is better in law schools to make sure that there are ideas from all perspectives, and in order to have that happen, they can't be suppressed. So
you don't want students shouting down other students or visiting professors, right? I mean, I'm honestly, I didn't think there was any chance we would differ on this, so I'm not.
Yes, no, I'm not.
Okay.
I'm not suggesting that we do differ.
You're against canceling people, I assume.
I'm not suggesting that we differ. What I'm saying is that these issues about speech on campus and the like are the kinds of things that are issues that are working their way, in different formats and different ways through the courts. And so I'm just being careful in terms of my answers.
Okay. I'm trying to lead you because I want to, because I think American civic health will be better off. You're going to be a hero. You are already a hero to lots and lots of kids, students, maybe some bound for the law, but more broadly, students across the country. And I think it's in America's public interest for them to hear you as an advocate for the full, vigorous, strong kid debate of different views. And so I suspect you are an advocate for vigorous and robust debate. I don't see how you might be constrained against saying that because of future cases, but I'm going to just assume we're mostly aligned on this.
I think that's a fair assumption.
Thank you. I do want to make, before I move on, just because we've had a number of members of this committee comment on cameras in the court. I've made my position on this clear a lot of times, but if I can give a tiny bit of friend of the court brief in advance, because I think when you're on the court and you all continue to debate this issue, I think it should be a decision for the Supreme Court to make about whether or not there are cameras in the courtroom, not a decision for the Article I branch to make for Article III. But I think it's incredibly important for us to recognize, because I think I differ from a lot of my colleagues on this who are advocates for cameras in the courtroom. I get their position that transparency is a virtue. Transparency is a good thing. I also believe that pen and pad can facilitate a whole heck of a lot of transparency just fine, and it's healthy for Americans to recognize the second and third and fourth order effects of cameras. A huge part of why this institution doesn't work well is because we have cameras everywhere. Cameras change human behavior. We know this. You don't have the same kinds of conversation over the dinner table with your family when you're wrestling through issues and apologizing for something and saying, I said this before, but maybe I should modify what I said. My tone was jerky. My substance didn't account for your position. there's a whole bunch of things that humans can do if they're not immediately mindful of some distant camera audience that they might be trying to create a soundbite for. And Instagram can be useful for some small things, but for intellectual discourse, it is not a friend. And I think we should recognize that the jackassery we often see around here is partly because of people mugging for short-term camera opportunities. And it is definitely a second and third and fourth order effect that the court should think through before it has advocates in there who are not only trying to persuade you 9 justices, but also trying to get on cable that night or create a viral video. So for what it's worth, I hope that the court doesn't respond to some well-meaning impulses from the Congress to push for cameras in the courtroom, but also some bullying. And there are ways that you can get to a lot of transparency. Audio recordings are increasingly released from the Supreme Court in timelier fashion over the past few decades. So for what it's worth, I'm glad that you on the court are making that decision, and I hope it isn't made for you by the Congress. I want to go back to the legitimacy of the Supreme Court. That term has been used a few times over the last 3 days. Do you think the Supreme Court is legitimate?
I do, Senator.
And so some of the ways that the court has been derided and called illegitimate by members of the Senate include, over the course of recent days and weeks, quote, leans into extreme partisanship, leans into extremism, twists the law, threatens basic liberties, has been hijacked by Republicans. These kinds of attacks undermine the public's trust in the court. We need the public to believe in the legitimacy of its government, including all 3 branches. So I would ask you, do you agree with these characterizations of the court that have been levied in this room over the last few days?
Senator, I have nothing but respect for my former judicial colleagues, my current judicial colleagues, and hopefully my future judicial colleagues. I do believe that we need legitimacy. I've said that that's the currency of the court, and I look forward, if I'm confirmed, to joining the institution.
So do you think there could be any opinion that would be handed down this term that could undermine the legitimacy of the court?
Senator, I think the Supreme Court makes its determinations, and all of them are precedents, and they are entitled to respect.
I'd like to come back to our conversation from yesterday. You pointed out a number of times that as both a district and now a circuit court judge, you were constrained and bound by the Supreme Court's holdings. You mentioned a couple of times that you haven't had a chance to do much constitutional interpretation for yourself. I largely agree with the way you framed most of that for the lower courts, but I think you would also agree with me that the job of a Supreme Court justice is different than a district court judge, and in certain ways from a circuit judge as well. When you serve on the Supreme Court, you'll have to interpret what the Constitution means, and based on what you told us about the constrained role on the lower courts, lower court decisions would then not be able to answer how you would approach the new job you would have on that highest court. And so that's why I thought our conversation on judicial philosophy yesterday was somewhat helpful. I'm not a lawyer, but I think you took a lot of us to law school yesterday in ways that were helpful. And in particular, you walked us through some different schools of constitutional and statutory interpretation in ways that I think were good for the committee, were good for the court, and were good for the public more broadly. So I guess I would ask you, if you could take us to law school one more time and walk us through some of the different approaches to substantive due process and unenumerated rights. What are the different ideas on the Supreme Court and in the broader legal community?
Thank you, Senator. I am not mostly familiar with the Supreme Court's precedents in this area. It's been a while now that the Supreme Court has determined that the 14th Amendment, which guarantees due process, includes a substantive component in addition to procedure. The term due process, one would think, is just about the procedures that the government has to afford you before it affects your life, liberty, or property. But the Supreme Court has also said that that protection extends to certain personal, individual rights that relate to dignity and autonomy, and that are deeply rooted in our nation's history and traditions, or implicit in the concept of ordered liberty. And the kinds of things the court has recognized pursuant to that line of jurisprudence are things like marriage, interracial marriage, the access to contraception, a woman's right to terminate her pregnancy, abortion, pursuant to or subject to the framework established in Roe and Casey, travel, the child rearing, the ability to direct your children. Those are some of the rights that have been recognized pursuant to the 14th Amendment due process clause. I'm less familiar with the sort of scholarly debate outside of the Supreme Court's rulings.
So will there be new ones in the future?
Senator, I am not able to forecast. In every case, the Supreme Court is looking at a particular set of circumstances consistent with the Article 3 requirement that the court look only at cases and controversies. So it would depend on what cases came before the court.
So I think that gets at the challenge here that you and I have been going back and forth on over the course of a couple of weeks, because I get the modesty points about being on the district court, but it seems pretty important to understand what the limits might be as a justice. And so I think this morning, again, you stated that I think the quote was that your judicial philosophy is your methodology. But I think that a judicial philosophy of some kind is necessarily an input into your judicial methodology and into every justice's actual jurisprudence on the court. And that's why I think it's important for us to unpack that, because the philosophies that you've outlined for the committee, again, I think yesterday's back and forth that you and I had on Breyer v. Scalia, is important, and you wouldn't claim any of those philosophies for yourself. And yet I think the philosophies ultimately instruct judges on the sources and the tools they consult, on how they discern intent, on whether the Constitution is protecting specific limited and defined principles or more general values, and whether modern values can be used to infuse our understanding of the Constitution. So again, when you narrated a bit of the debate between Justice Breyer, I know you've got lots of intellectual inputs in life, but you've credited him as a brilliant jurist and role model before. And the Scalia debates, you didn't really tell us who you thought got the better of the argument. And so I think throughout these 2 days, you've focused a lot on what the Supreme Court has said, and I think that is helpful and important. But I've been also trying to get at what you think the limits might be on what Justice Jackson would be constrained by. So I feel like, I believe we still haven't heard your judicial philosophy, and I wish I'd made more progress with you on that. But what we do know on a personal note is that these committee 3 days have been very long, and I want to thank you, and got to have a nice conversation with your parents earlier, your whole family, for what you've endured and for spending time with us, and obviously wish best wishes to you and your family. Thank you, Judge.
Thank you.